Thank you for that gracious introduction, Mark. Good evening, everyone. I join with you in acknowledging the traditional owners of the land on which we meet. Tonight, we come to honour and learn from two of the greats in our intellectual tradition, one from the Church and one from the law. Pope Leo XIII, who authored, or at least caused to be authored, the great social encyclical of the Catholic Church, Rerum Novarum, which was published in 1891, and Henry Higgins, the Australian judge, who decided the Harvester case on this day 110 years ago. Judgment was delivered on this very day in the Supreme Court building here in William Street, Melbourne. Just to remind you how far we've come, Justice Higgins, whom we rightly honour tonight, once wrote to an American colleague telling him, "I've been asked by the Minister for External Affairs and Territories to go up to the Northern Territory and put labour matters straight. The place is in the tropics, and most of the people are Chinese, Japanese and Malays. It's a great problem for Australia. Can the place be developed by white labour?" We are now citizens of a proudly multicultural, multicoloured nation which recognises the first Australians and their relationships with the land. A relationship which has often been maintained unbroken, especially in the north of Australia, despite generations of oppression driven by the terra nullius mindset. Higgins was not a Catholic. In fact, he was a Northern Irishman, a Protestant whose father was a clergyman in the Church of Ireland. Henry was 19 years old when the family migrated to Australia. He was one of our founding fathers. He remained a strong advocate for home rule in Ireland. It was probably that advocacy which commended him to some of the Catholic leaders here in Victoria, and which established his good relations with Archbishop Carr in this city. He attended the 1891 Federal Convention in Sydney, which rejected the proposal that the Commonwealth Parliament exercise any power in relation to industrial disputes. Delegates thought these disputes should remain within the exclusive purview of the states. Shortly after the Sydney Convention, Pope Leo XIII published the encyclical Rerum Novarum. Some, including Bob Hawke and Michael Kirby in recent years, have suggested that Rerum Novarum had a major influence on the thinking of Higgins. Higgins was later one of the Victorian delegates at the 1897-98 Federal Convention. He was the one who proposed that the Commonwealth Parliament should have power to make laws with respect to the conciliation and arbitration for the prevention and settlement of industrial disputes, extending beyond the limits of any one state. This proposal was carried narrowly by 22 votes to 19. Bob Hawke claimed in a 2010 lecture that the groundbreaking philosophy of Rerum Novarum deeply influenced the thinking and arguments of Higgins, who, with Kingston from South Australia, finally won the day. When the High Court of Australia bench was increased in size from 3 to 5 in 1906, Higgins was appointed together with Sir Isaac Isaacs. It was not until 1920 that they would win the day, overturning the views of the first High Court judges who had clung to the idea that the new Commonwealth of Australia could operate only if the states maintained their supposed reserve powers and were spared interference by the Commonwealth in the exercise of their governmental functions. As well as being a Justice of the High Court, Higgins was also the President of the Court of Conciliation and Arbitration from 1907 to 1921. His first case on that court was the decision we celebrate today. It was the Harvester case, more accurately known as Parte Hv Mccain. The case arose when excises and tariffs were more significant than they are today. There was an excise imposed on agricultural implements, such as the harvesters manufactured by Mr. Mackay. Under the Excise Tariff Act, the excise would not apply to goods manufactured in Australia under labour conditions declared by the court to be fair and reasonable. Higgins had received 110 applications for exemptions from various Victorian manufacturers. He decided to treat Mackay as a test case because his factory was one of the largest and had the greatest number and variety of employees, and because his application was to be keenly fought. Higgins was one of those Irishmen who didn't mind a fight. He was a very single-minded judge. On the High Court, he would often write alone, even when he agreed broadly with the decision and reasoning of his fellow judges. Higgins spent 20 days of court time investigating the fairness and reasonableness of the labour conditions for Mackay's employees. His inquiry focused on the level of wages paid. He lamented that the Parliament had not given any guidance as to how a judge would determine what was fair and reasonable. Having been a member of the House of Representatives and the Attorney-General in the nation's first Labor government, he felt justified in stating his views on the Parliament's failure to be sufficiently precise in formulating legislation since his departure to the bench. He wrote, "It's to be regretted that the legislature has not given a definition of the words. It's the function of the legislature, not of the judiciary, to deal with social and economic questions. It is for the judiciary to apply, and when necessary, to interpret the enactments of the legislature." He thought he was being placed in a false position, lamenting the strength of the judiciary and the public confidence is largely owing to the fact that the judge has not to devise great principles of action as between great classes, or to lay down what is fair and reasonable as between contending interests in the community, but has to carry out mandates of the legislature evolved out of the conflict of public opinion after debate in the Parliament. He saw the risk of being brought within the range of political fire. Having stated his political reservations, he stepped right into the fire. Over the next 14 years, he relished the task, though it ended in tears with his resignation as President of the Court of Conciliation and Arbitration. By then, he thought that Prime Minister Billy Hughes had undermined the authority of his court by creating specialist tribunals to deal with particular disputes in particular industries, such as the coal industry. In the harvester case, Higgins ruled out from the beginning the spurious argument that a fair and reasonable wage was what the market would bear. Not to him any neoliberal nostrum such as "let the market decide." He observed the remuneration could safely have been left to the usual but unequal contest, the higgling of the market for labour, with the pressure for bread on the one side and the pressure for profits on the other. He said, fair and reasonable remuneration is a condition precedent to exemption from the duty, and the remuneration of the employee is not made to depend on the profits of the employer. If the profits are nil, the fair and reasonable remuneration must be paid, and if the profits are 100%, it must be paid. Now this was his truly revolutionary insight. He wrote, "The standard of fair and reasonable must therefore be something else than what the market will bear. And I cannot think of any other standard appropriate than the normal needs of the average employee, regarded as a human being living in a civilized community." He had invited the barristers at the bar table to propose any alternatives, and they could not offer one. The barristers for the employers were keeping their powder dry. What's often forgotten by the modern advocates of the Harvester judgment is that the High Court, within a year, struck down the decision on the grounds that the Excise Act was not really a taxation act at all, but an act to regulate labour conditions, and as such, beyond the competence of the Federal Parliament. Higgins saw fit to sit on the appeal and, unsurprisingly, was in the minority with his usual dissenting colleague, Isaac Isaacs. Determining what was fair and reasonable, Higgins had decided to view the task as formulating an agreement not just between one employer and his employees, but as a collective agreement. An agreement between all the employers in a given trade on the one side and all the employees on the other. The first and dominant factor would then be the cost of living as a civilized being. Now remember, these were the days before uniform Commonwealth income tax and before the days of income transfer through the tax system and well before the days of comprehensive welfare plans. There was no social welfare net such as exists today, frayed and stretched though it may be today. Higgins decided that when determining free and reasonable remuneration for the unskilled labourer, he would need to assess the cost of proper food and water, necessary shelter and rest, clothing, and a condition of frugal comfort estimated by current human standards. The unskilled workers working an 8-hour day were receiving at most 36 shillings a week, 6 shillings a day for a 6-day working week. Higgins set about ascertaining the cost of living for an average male worker with a wife and 3 children, the amount which was to be paid for food, shelter, clothing for an average labourer with normal wants and under normal conditions. He received a lot of evidence from working men's wives, which was absolutely undisputed. He noted the rapid rise in rents and meat prices. Explaining the decision 8 years later in the Harvard Law Review, he wrote, "Treating marriage as the usual fate of adult men, a wage which does not allow of the matrimonial condition and the maintenance of about 5 persons in a home would not be treated as a living wage." He concluded that the basic wage would then be the same for the employee with no family as for the employee with a large family, but that it rests on Walt Whitman's divine average, and the employer need not concern himself with the employee's domestic affairs. Even accepting the primary principle enunciated by Higgins, we would all have some difficulty in applying it in the same way today. For example, he explained to his American readers in 1915, "The principle of the living wage has been applied to women, but with a difference, as women are not usually legally responsible for the maintenance of a family. A woman's minimum is based on the average cost of her own living to one who supports herself by her own exertions." Concluding his 1915 Harvard Law Review article with a fine moral peroration, he enunciated the key principle. Each worker must have, at the least, his essential human needs satisfied, and that among the human needs there must be included the needs of the family. Sobriety, health, efficiency, the proper rearing of the young, morality, humanity, all depend greatly on family life, and family life cannot be maintained without suitable economic conditions. He was unimpressed with the one-sided nature of the employer's valuation of employees. Mackay, in evidence, had stated, "I pay the men what I consider them to be honestly worth. In fixing the wages, I've endeavoured to get labour at the cheapest price that I honestly could." Higgins observed, "I can only say that I'm not going to accept as final the employer's unchecked opinion as to an employee's worth in wages, any more than I should accept the value of a horse on the word of an intending vendor. He noted that the agricultural manufacturing industry was not a parasitic industry, which could not exist except at the expense of the employees by drawing the lifeblood from them. The effect of his decision to increase the daily rate for the unskilled worker from 6 shillings to 7 shillings would probably be merely that the employer must elect between paying wages according to the excise standard and paying the excise duties. He was later to claim that the increase for most workers was from 5 shillings and sixpence to 7 shillings, a wage rise of a mere 27%. Nowadays, his critics claim that such a steep wage rise, if it had succeeded the High Court challenge, which it did not, would have simply placed large numbers of unskilled workers on the dole queue. Even though the High Court struck down the Excise Act the following year, with Mr Mackay refusing to pay the excise duty and defending the action to recover the excise on the basis that the Act was invalid, Justice Higgins still felt vindicated and wrote in the Harvard Law Review 8 years later that the principles adopted in the case for ascertaining a fair and reasonable minimum wage have survived and are substantially accepted, I believe universally, in the industrial life of Australia. Higgins's reasoning on what was a fair and reasonable wage for unskilled workers came to be regarded as a living wage and the basis upon which the court would arbitrate the settlement of industrial disputes. The living wage in time became the basic wage in Commonwealth and state industrial awards. The basic wage was absorbed into total award rates in 1965, but re-emerged in awards in 1997 as the federal minimum wage, albeit at a level that called out for the Harvester standard to be applied afresh. The Fair Work Act of 2009 renamed that wage as the national minimum wage and made it the general minimum wage entitlement across Australia. The terms of this current legislation are very much informed by Harvester, but the enduring principles of Harvester, the living wage principle, and our modern understanding of human rights, sadly have not been applied in the decisions made under it. Throughout his judicial life, Higgins maintained a regular correspondence with Felix Frankfurter, law professor at Harvard, and later a long-serving justice of the US Supreme Court. Higgins wrote 3 lengthy articles for the Harvard Law Review in 1915, 1919, and 1920. They were entitled A New Province for Law and Order. The Americans were still infected with the belief that the untrammeled market could best decide wages, like the price of any other commodity. Frankfurter was enamoured of Australia's novel system of conciliation and arbitration. When soliciting the first article for the Harvard Law Review in 1915, the editor wrote to Higgins saying, "Especially on such a topic as labour law, we in America have much to learn from foreigners. Your realistic and sensible treatment of this branch of the law in your conduct of arbitration proceedings in Australia contrasts so favourably with the artificial and fruitless discussion of natural rights and liberty of contract in which American lawyers indulge, that the discussion of it from a lawyer's point of view from your pen would be a real service to the bench and bar of this country." Higgins admitted to Frankfurter, "The name that I chose for the article was influenced, I confess, by the desire to placate any old-fashioned subscribers to the Harvard Law Review." On receipt of the first article, the editor wrote expressing Frankfurter's gratitude and conceding, "Many lawyers here will say that it doesn't deal with a legal topic. To me, the principles and precedents that you've worked out seem to be the essence of law, a new branch of jurisprudence that must be scientifically studied and developed." When the new editor was commissioning the second article in 1918, he wrote, "Your first article we have always considered to be one of the best that ever appeared in our review." The poet Mary Gilmore had written to Higgins at some length on the 17th of September 1909. By this time, Gilmore was a regular contributor to the Australian Worker. She used to edit and often write the women's page. She wrote, "In regard to the minimum wage and what it includes, it seems to me that to take the family as the unit is scarcely just." Remember, this is a poet writing to a judge. "The just state does not delegate to any section of the community the maintenance of the family, and would not therefore countenance the payment of a family wage by any but everyone, that is, the whole. But the whole thing seems to me thus, that the state has a perpetual covenant with the family, which reproduces itself to create and maintain the state, and therefore has a claim against the state, and that the brief labour covenants are a matter of individual unit to individual unit, and that the two are separate, and certainly should not, but cannot be successfully covered by any law made to cover both. This, of course, does not in any way mean there should be no regulation of wages," she wrote. "It only means that the wage and the family are separate entities." From my researches in the National Library, all I can find is what is in the files as a draft response to Mary Gilmore, but I presume it was sent because there is a later reply from the poet. The draft response is worded thus: "Dear Madam, I have read and reread your thoughtful letter. I understand that you form the view, which was held by Plato and others, that families should be supported by the state, and that you think I should ignore the needs of the family in fixing wages. My duty is merely to carry out the will of Parliament as expressed in the acts which I have to administer, and I have no right to assume that Plato's theories with regard to the state and children will be adopted. In the harvester case, I had to find what was fair and reasonable remuneration for certain classes of employees. I considered that no remuneration could be treated as fair and reasonable which did not, at the least, allow for the satisfaction of the normal wants of an average employee regarded as a human being living in a civilized community. Among the normal wants, I include food, shelter, clothing, and family life. This family life cannot be had under existing conditions without money wherewith to maintain a wife and children. I do not take the family as the unit as you think. I take the employee as the unit with normal wants. The principle which I adopted in the harvester case I've applied in my awards. For in awards for settling disputes, the essential condition of peace is that the employee receive a fair and reasonable remuneration. I do not say anything with regard to the merits or faults of large schemes for social betterment." Gilmore wrote again on the 30th of July, "It never occurred to me till I read it that though you made no mention of it, I'd asked you to criticise the law you have to administer. I was so anxious to find the wise man." Writing to Frankfurter on the 15th of October 1916, Higgins said, "My view is that there is no subject of dispute which should be treated as ultimately non-justiciable. They told us that labour disputes were non-justiciable, as there were no principles of right to guide us. But we found principles, invented principles if you like, drew them from the storehouse of justice and humanity." Higgins and his wife Mary Alice had only one child, a son Mervyn, who was educated at Melbourne Grammar, Melbourne University and at Oxford. Mervyn went to the war, World War I, and was killed on the 23rd of December 1916. After Mervyn's death, Higgins applied himself even more earnestly to his work for conciliation and arbitration. He wrote to Frankfurter on the 16th of September 1918, saying, "Sometimes, however, I am weighed down by the grief which you know of, but it cheers me to fancy that I am doing just what my boy would like me to do. What, after all, am I among so many who suffer? There are many homes suffering here, we have lost about 52,000 men. Just 6 months after Mervyn's death, he'd given a fairly philosophical address to what was unfelicitously called the Millions Club in Sydney. He told them, "What, after all, gentlemen, is that to which we direct all our legislation, all our administration, all our public institutions? It is the service and benefit of human beings. When we talk of benefits to a country, we mean benefits to the people of that country. When we talk of benefits to a city, we mean to the people of that city. There's no asset so valuable as well-nourished, healthy, sane, moral, intelligent men, women and children. The best country is the country with the largest proportion of such persons. Members of this club want, I suppose, millions of white people for the ample territory of this continent, and they are right. But they also want, I presume, full civilized conditions for these people. If we want to see more spirituality of life, we must support life first." Quoting Hooker's Ecclesiastical Polity, he said, "The first impediment which naturally we endeavour to remove is penury and want of things without which we cannot live." Musing on the effects of war, and no doubt remembering Mervyn, he proposed solidarity between the rich and poor as one of the fruits of war. He said, "The war is tending to the solidarity of people rich and poor. Men come back from the trenches, sons of the wealthy, sons of the humble, duke's son and cook's son, after being reduced to the elementary needs of life, after facing the damp and the dirt and the cold, after facing the horrors of the battlefield, and they come back with a vivid sense of their common humanity. After war, the problems of peace. Shall we realise the paradox that the dividend out of public prosperity is greater and better than private gain? Shall we realise that each man gets more out of life by giving than by getting? That in the old words, it is more blessed to give than to receive?" Higgins never abandoned his interest in politics, and he was fascinated by American politics after the First War. On the 14th of October 1917, he wrote to Frankfurter saying, "Even if the Germans were all criminals, we have to live in the world with them. Vengeance is a fruitless thing. I feel that the best vengeance my dead boy could hope for would be an integrated world and organised humanity." On the 25th of September 1920, Higgins resigned from the Court of Conciliation and Arbitration. From the bench, he delivered an impassioned indictment of the temporary specialist tribunals being set up by the Hughes government. He said, "From the nature of the case, any such temporary tribunal must be merely opportunist, seeking to get the work of the particular industry carried on at all cost, even the cost of concessions to unjust demands, or encouraging similar demands from other quarters." He asserted, "A tribunal of reason cannot do its work side by side with executive tribunals of panic." Having detailed his differences with Prime Minister Hughes over a long period of time, he concluded, "Yet I do not think that even such treatment would justify my resignation. My resignation is due to my opinion that the public usefulness of the court has been fatally injured." This must go down as one of the all-time great judicial dummy spits in Australian history. After his resignation, he wrote to Frankfurter, "I could not do anything else. Hughes has recklessly ruined a most promising experiment. He seems to have no knowledge of the psychology of the workers." Higgins was convinced that it was the bigger employers who'd got to Hughes. He took great heart from the resolution of the Trades Hall Council carried on the 24th of February 1921, that this council views with profound regret the pending resignation of Justice Hughes from the presidency of the Court of Conciliation and Arbitration, and expresses the hope that his services may be retained in the interests of social justice and industrial peace. He told Frankfurter, "Yes, I remain on the High Court, but important though the work there is, it is not, from the true perspective, 1/10 as important as the other work. Too much word chopping. In the Court of Conciliation, I dealt with life. The work was constructed. That's quite a statement, given that it was made just 8 months after he and Isaacs had the big win in the engineers case, holding that the Parliament had power to make laws with respect to industrial disputes across state boundaries, even if the state or an instrumentality of the state was a party to the dispute. Lawyers in Australia are still talking about the engineers case and the win by Higgins and Isaacs. In 1922, Higgins brought together his 3 Harvard articles and expanded them into a book of the same title, A New Province for Law and Order. In the preface he wrote, "I had to learn the business with no book of instructions, no teacher other than experience, no kindly light except for the pole star of justice." Looking ahead to the future of industrial tribunals, he opined, "Learned men say that navigation by steam was impossible, that air flying was beyond human powers, and they were wrong. They told us that a law for minimum wages was absurd, that the wage fund was fixed by irreversible economic laws, that the laws so-called of demand and supply were inexorable, that industrial tribunals were impracticable, and they were wrong. We all make mistakes, and we have to learn by our mistakes. The man who makes no mistakes, it is said, generally makes nothing. Industrial tribunals are doing their best for human life, the only wealth. It is the noblest objective. We work and we learn." In 1924, he travelled to Oxford and delivered an address on the Conciliation and Arbitration Court. He told his audience, "On this side of the world, in France as well as in England and America, there seems to be a disposition to look on Australia as a kind of experimental farm for social enterprise." He took pride in listing achievements such as the Torrens system for registration of land titles, the compulsory ballot at elections, and women's suffrage. He mused that the goal of all legislatures is the good of men, women and children. There is no asset of any state so valuable as its human life. He expressed his pride in the Conciliation Court, which was charged with trying to avoid strikes and disputes which extended beyond state boundaries. He boasted from 1905 to the closing months of 1916, there were no such strikes at all. He explained the key idea of the basic wage. It refers to that part of the wages which is necessary for man's manhood, apart from any special or distinctive skill or qualifications required for his particular occupation. The basic wage, as defined by the court, is founded on the normal needs of the average employee, regarded as a human being living in a civilized community. In finding the basic wage, we try to ascertain what's necessary remuneration for an unskilled labourer, necessary for food, shelter, clothing, and something to come and go on, so that he may have civilized conditions of life for himself and a small family on a frugal scale. In finding this basic or living wage, we treat marriage as the normal fate of a normal man. After Higgins's death, his widow wrote to Frankfurter on the 8th of October 1929 saying, "I feel that my husband has been spared much disappointment. The Federal Arbitration Court, to which he gave the best of his brain and heart for so many years, is tottering and in a few days may be abolished. Hughes wrecked it in his time when Prime Minister and now is its champion." 110 years on, we all know that even if the principles enunciated originally by Higgins be accepted, they could never be applied in the way that Higgins applied them. The world is now a very different place. The stereotypical unskilled worker is not a married man with a wife and 3 children at home anymore. Most unskilled workers never were. The economic historian W.K. Hancock, in his book Australia, writes, "In 1920, the chairman of a special basic wages commission pointed out that Australian industries were paying for 450,000 non-existent wives and 2,100,000 non-existent children. Just as the living situation and domestic circumstances of workers are more diverse nowadays, so too is the range of options available to the state for ensuring that working individuals are able to live frugally and with dignity. There is a need to consider wages, tax transfers, the superannuation guarantee levy, social security payments, and the suasive effect of international human rights and other international legal instruments, such as Article 23 of the UN Declaration of Human Rights, which provides everyone who works has the right to just and favourable remuneration, ensuring for himself and his family an existence worthy of human dignity and supplemented, if necessary, by other means of social protection. This provision of the UN Declaration of Human Rights has been buttressed by Article 7 of the International Covenant on Economic, Social and Cultural Rights, which provides for the right of everyone to the enjoyment of just and favourable conditions of work, which ensure, in particular, a decent living for workers and their families in accordance with the provisions of the present covenant. Anyone tempted simply to replicate Harvester in both principle and application would need to call to mind Paul Keating's great boast in 2007 when he had John Howard's work choices in the gun. Keating boldly claimed, "There have been two seminal events in wage fixing in Australia over the past century. The first was the movement to a national or centralised wage fixing system that came with the Harvester judgment in 1907. The second was the dismantling of that centralised wage fixing system by the Keating government in 1993. That change created a decentralised wages system built around enterprise bargaining with an arbitrated safety net for the low paid. But that shouldn't stop us from reasserting the basic principles of Harvester, nor from seeking new ways to apply the principles to new circumstances. At the centenary of Harvester 10 years ago, Julia Gillard rightly lauded Higgins's approach as embodying the idea that Australia should be a country where the obligation to work should be met by the right to decent treatment at work. Now, it's become fashionable, particularly in Catholic circles, to link Higgins' Harvester judgment with the encyclical Rerum Novarum. Marking the centenary of the Conciliation and Arbitration Act in 2004, none other than Michael Kirby, proud of his own North Irish Protestant roots, declared in a paper entitled Industrial Conciliation and Arbitration in Australia, a Centenary Reflection. He said, in the 1890s, Higgins embraced ideas that had been propounded in 1891 by Pope Leo XIII in his encyclical Rerum Novarum. As you will understand, said Kirby, it is no small thing for a person with such an Ulster background to adopt papal ideas. It may well be that Higgins' connection with Catholic circles of thought was fostered by his natural attraction to and with those who favoured Home Rule for Ireland. When he was appointed to the High Court, Archbishop Carr, the Catholic Archbishop of Melbourne, wrote to him enthusiastically, saying, "No man can afford to enjoy his promotion so much as the man who has consistently acted on principle when principle seemed to be a bar to promotion. To no section of the community will your appointment give greater pleasure than to Irish Catholics." A year later, Higgins wrote to Carr, congratulating him on an anniversary of episcopal ordination. Carr responded, "I value very much the good opinion of one who is a disinterested spectator of passing events." Higgins' great political ally had always been Alfred Deakin, who had then appointed Higgins to the High Court. At the time of his appointment, Higgins was corresponding with Arthur Green, the Anglican bishop in Ballarat. The bishop reported that his diocesan administrator, Father Guilfoyle, has had conversations with not a few Catholics of Ballarat all of whom view with disfavour the opposition to Mr. Deacon, and he gives it as his opinion that Mr. Deacon's return is a fair certainty. I can do very little, wrote the bishop, as my intercourse with the Catholic electors is necessarily limited, but what little shall be done. We must move, however, very cautiously, as I believe that owing to the present state of public sectarian feeling, our open advocacy of his candidature would be seriously injurious to him. I have my doubts that Higgins would have been directly influenced all that much by Pope Leo's writing in Rerum Novarum, except insofar as the papal utterances reflected the thinking of many fair-minded people at that time, regardless of their religious affiliations. In the wake of the political and economic revolution sweeping through Europe, Leo XIII published his encyclical Rerum Novarum on Capital and Labour in 1891. He espoused the right to ownership of private property and the right of persons to associate freely, including the right of workers to form unions. He passionately rejected socialism and identified the purpose of work as being ultimately the ownership of property. He lamented the conflicts in the world arising in part because of the enormous fortunes of some few individuals and the utter poverty of the masses. Thus the need to speak on the condition of the working classes. He saw a need to outline the relative rights and mutual duties of the rich and of the poor, of capital and of labour. Leo wrote, "Public institutions and the laws set aside the ancient religion. Hence, by degrees, it's come to pass that working men have been surrendered, isolated and helpless to the hard-heartedness of employers and the greed of unchecked competition." Leo thought that the right to property was a natural right, and the fact that God has given the earth for use and enjoyment of the whole human race can in no way be a bar to the owning of private property. He postulated that the family is a true society, and one older than any state, having rights and duties peculiar to itself which are quite independent of the state. So he wrote, "That right to property, therefore, which has been proved to belong naturally to individual persons, must in likewise belong to a man in his capacity of head of a family. Nay, that right is all the stronger in proportion as the human person receives a wider extension in the family group. It's a most sacred law of nature that a father should provide food and all necessaries for those whom he has begotten. And similarly, it's natural that he should wish that his children, who carry on, so to speak, and continue his personality, should be by him provided with all that's needed to enable them to keep themselves decently from want and misery amid the uncertainties of this mortal life." Leo was all in favour of freedom of contract and encouraged harmony and agreement between capital and labour, but he was insistent that there was a dictate of natural justice more imperious and ancient than any bargain between man and man, namely that wages ought not to be insufficient to support a frugal and well-behaved wage earner. Having this part of his argument on the right and capacity to own property, Leo observed, "If a workman's wages be sufficient to enable him comfortably to support himself, his wife and his children, he will find it easy, if he be a sensible man, to practice thrift, and he will not fail, by cutting down expenses, to put by some little savings and thus secure a modest source of income. Nature itself would urge him to do this. We've seen that this great labour question cannot be solved save by assuming as a principle that private ownership must be held sacred and inviolable. The law therefore should favour ownership, and its policy should be one to induce as many as possible of the people to become owners." He saw three advantages flowing from this. Property would become more equitably distributed, the gulf between the rich and poor would be narrowed, and people would cling to the country in which they were born, for no one would exchange his country for a foreign land if his own afforded him the means of living a decent and family life. I have no doubt that these sentiments would have resonated with Higgins had he read them. I'm not quite so convinced that the son of a 19th century Church of Ireland minister would have been swayed to change his views. One can make the case for a correlation of views. Call me a doubting Thomas or a suspicious Jesuit, but I would need more evidence to establish causation. It is, of course, a good thing to have an historical sense of the origins and the impact of the Harvester decision and Leo's Rerum Novarum more than a century ago. Our challenge is to apply the new insights gained to our current circumstances so that we might contribute to a just and flourishing society for all in another period of great social and economic change. Rerum Novarum was written at a time of great social change brought about by the Industrial Revolution. Our century will be marked by equally significant change through technological advances and digital disruption. Realising the fruits of the Harvester judgment in these times of great change will require the articulation of and commitment to a new accord between government, business and civil society. Implicit in this accord would be the sharing of responsibility to achieve the common good. Such an accord would need to temper the power and expectations of capital and offer business support to pursue patient capital. In return, businesses must not be so burdened by unnecessary regulation as to undermine their capability to generate profits and employment opportunities, especially for our young or low-skilled. Governments also can no longer argue that they are mere stewards of the economy. They must play an active role in both the architecture of a new industrial paradigm and the creation and provision of opportunities for dignified employment, especially for those who have been excluded by the employment market. Trickle-Down Economics, by its very title, is a top-down approach to wealth distribution. It's failed those at the bottom of the pyramid. For our 21st century world, we need to develop a bottom-up approach to distribution, first ensuring that we have an adequate safety net for those who cannot participate in the workforce. We need to remove this from elected politicians and create an independent commission to develop evidence-based benchmarks to ensure that income support payments and pensions are adequate for people to live a frugal yet dignified life. The other great challenge for us is how we determine what are fair and just wages for those in low-paid and insecure work. The digital economy brings with it different requirements and expectations of work and the workplace. Nonetheless, we cannot allow this to undermine important employment protections, such as sick and recreation leave and other hard-fought benefits, such as maternity leave. These benefits give practical meaning to humanity and, more importantly, reinforce that people are more than a means of production and mere inputs into the economy. The intersection between being in work and out of work is much more complex than it was at the time of the Harvester judgment. Our labour market is one of growing casualisation and insecure employment, often forced upon employers who are no longer able to carry the costs and long-term liabilities of permanent employment. Economic risk is being shifted from government to employer and then finally to the employee, particularly through the marketisation of social services. This is unacceptable. Our industrial relations framework must place a new premium on those roles so as to drive the risk back to those best able to manage it. The incentive must be to create secure and full-time employment. The question of income adequacy is a vexed one for government and business alike. While governments rightly invest significant resources in the provision of free and subsidised education, health and childcare, the cost of raising a family, all too often extends beyond the means of low-income households. Indeed, research recently commissioned by our Catholic Social Services Australia found that a low-income family with 2 children requires an additional $89 a week to meet a relatively basic standard of living. We need reliable, independent means for determining what is sufficient to live in a civilised community. It's time to reflect on how the minimum wage is set, and in particular what information is required for that determination. The Fair Work Commission, in its annual wage review this year, acknowledged that the modest increase proposed would not lift all award-reliant employees out of poverty, measured by household disposable income below a 60% median income poverty line, particularly those households with dependent children and a single wage earner. But to do so was likely to have adverse employment effects on those groups who are already marginalised in the labour market, with a corresponding impact on the vulnerability of households to poverty due to loss of employment or hours. The government, for its part, submitted that the tax transfer system was more efficient in equalising the distribution of income among Australian households. The Commission conceded that the changes to the tax transfer system in the past two budgets have reduced the financial assistance that's provided for low-income families with children. Having acknowledged the problem and the shortfall, the Commission handballed both back to society generally with the hand-washing observation: the high and continuing levels of child poverty indicate that the combination of wages and social welfare assistance are not sufficient to ensure that the needs of all low-wage families are met. We view this as a serious matter for society, the Commission said. This conclusion is supported by the evidence that about 1/3 of people in poverty lived in households for which wages were the main source of income, and that about half of these families had children. The Commission has decided that family poverty is the Commonwealth Government's responsibility to be addressed through the welfare system. But the Commission knows that the government's budgetary strategy is to reduce the financial support for families, not increase it. There is now a standoff between the institutions setting the wages safety net and the social safety net, with a devastating effect on the lives of the working poor and their families. In Harvester, Higgins ensured protection for the stereotypical family of a single breadwinner in full-time employment, supporting the couple with their average number of children. Our task today is so much more complex. For example, we need to consider the position of the working sole parent who is not in full-time employment. And many of these sole parents are women. The feminisation of the labour force is coupled with the feminisation of poverty. Lower wages for women who work disproportionately in low-wage sectors is an acute equity problem for our society, a problem which never occurred to Justice Higgins, even after Mary Gilmore took him to task. What is the demarcation line between the wages safety net and the social safety net? At what point can the wage-setting tribunal leave the alleviation of poverty in wage-dependent families to government? At what point can the Fair Work Commission legitimately say the job is with government? Ideally and consistent with principle, as much as possible of the disposable income of individuals and families should come through the wage packet. If governments want to keep wages low, they need to improve the social safety net. Sally McManus, Secretary of the ACTU, was right when she said last week, the promise of Harvester was financial security for working people, not barely keeping from starving and making endless sacrifices to keep the lights on. She warned, we're rapidly moving towards the creation of an American-style working poor, a class of people who barely keep their heads above water, despite working full-time, sometimes in multiple jobs. Corporate profits rose 40% last year, and full-time workers can't afford to feed and clothe a family. She said the system is broken, and I agree with her. We are all on notice. The Fair Work Commission alone cannot or will not set the national minimum wage so as to ensure that even working Australians are not living in poverty. We need to consider also the tax transfer system and the social security system. Justice Higgins saw a new province for law and order with the conciliation and arbitration of disputes, setting an income standard for the average family to live with dignity and frugality. So too, we should see a new province for law and order in the 21st century, with the setting of appropriate levels of social security, including the New Start allowance, and tax transfer arrangements permitting all persons to live with dignity and frugality, regardless of their prospects of finding full-time employment and regardless of their domestic living arrangements. Pope Francis says, today everything comes under the laws of competition and the survival of the fittest, where the powerful feed upon the powerless. As a consequence, masses of people find themselves excluded and marginalised, without work, without possibilities, without any means of escape. In this year's Catholic Social Justice Statement, entitled Everyone's Business, Developing an Inclusive and Sustainable Economy, the Australian Catholic bishops set out 5 fundamental criteria. 1. People and nature are not mere tools of production. 2. Economic growth alone cannot ensure inclusive and sustainable development. 3. Social equity must be built into the heart of the economy. 4. Business must benefit all society, not just shareholders. And 5. The excluded and vulnerable must be included in decision-making. These principles point to the need for greater attention to the needs and entitlements of those who are dependent on social security payments for their survival and access to the labour market. I concede that it is legitimate for government to provide incentives for people to access the labour market, including social security payments lower than those payable to persons who have no prospect of accessing the labour market, whether because of age or disability. But it is just wrong for governments to keep payments such as New Start and the Youth Allowance at abysmally low levels in the name of budget repair, when there are insufficient jobs available and no realistic prospect of employment. It's now 5 years since the Business Council of Australia told the Australian Parliament the rate of the New Start allowance for job seekers no longer meets a reasonable community standard of adequacy and may now be so low as to represent a barrier to employment. That's not the Catholic bishops, that's the Business Council of Australia. It's time for our major political parties to commit to the establishment of an independent commission to set evidence-based benchmarks ensuring adequate income support payments for those Australians unable to get full-time employment through no fault of their own. This is a key plank for the new province of law and order. We Australian Catholics need to apply Pope Francis's insight in Evangelii Gaudium to our own political and economic context. Pope Francis writes, as long as the problem of the poor are not radically resolved by rejecting the absolute autonomy of markets and financial speculation, and by attacking the structural causes of inequality, no solution will be found for the world's problems, or for that matter to any problems. Inequality is the root of social ills. The dignity of each human person and the pursuit of the common good are concerns which ought to shape all economic policies. The IMF has identified widening income inequality as the defining challenge of our time. We need to develop a new province for law and order, true to the principles enunciated by Higgins in Harvester and by Leo in Rerum Novarum. Just as Higgins and Leo were writing at a time of economic and social revolution, so too we are thinking and acting in the midst of a revolutionary cycle. It's well expressed by Pope Francis in his encyclical Laudato Si. He says, we were created with a vocation to work. The goal should not be that technological progress increasingly replace human work, for this would be detrimental to humanity. Work is a necessity, part of the meaning of life on this earth, a path to growth, human development and personal fulfilment. Helping the poor financially must always be a provisional solution in the face of pressing needs. The broader objective should always be to allow them a dignified life through work. There can be no sustainable budget repair without ensuring a robust safety net and an assured leg up for those missing out through no fault of their own. We need to recommit to work for all those who are able and willing. We need to recommit to social assistance for all those who are not able. We need to ensure that a life of frugal dignity is within the grasp of all citizens. Deliberately placing some citizens beyond the reach of a dignified life of frugal dimensions is not a legitimate option. And we can no longer leave it to the Fair Work Commission and our politicians on budget night. The Fair Work Commission has put us on notice. They don't think it's their job. And our politicians have shown that they are no more equipped to set the needy person's appropriate welfare payments than they are to set your wages on budget night. Pope Francis is articulating the concerns of many about the social and environmental impacts of the dominant economic system. He's called for a change in the attitudes and practices of all of us, but placed particular responsibility on those with the power to change the economic environment through laws that are capable of protecting the common good. We need men and women to commit to this task, guided by the pole star of justice, as was Justice Higgins. We need the kindly light of a new province for law and order. Thank you.
I too would like to acknowledge the traditional owners of the land that we're meeting on today, the Wurundjeri people of the Kulin Nation, and pay our respects to their elders, past, present and future. And as said, my name is Bridget and I'm the coordinator of adult justice projects at Jesuit Social Services, a social change organisation where I've been based for the last 4.5 years. I'd like to thank Frank for inviting me to be his respondent to the Rerum Novarum Oration, and thank him for his really most inspiring presentation tonight. To be honest, I didn't know much at all about Rerum Novarum before I was asked to be Frank's respondent. I asked my father, a Uniting Church minister and theologian who taught Frank theology many years ago, and was provided with a gruff but accurate description of it being 19th century Catholic social justice. It was Dad's over the phone advice, and actually a very helpful step in the right direction. As I spoke with Dad and did my obligatory Google search and listened to Frank, I was struck by both the consistencies and the inconsistencies of the tenets of Rerum Novarum and of Justice Higgins and that Harvester decision, and of the early efforts in this country towards a fair and reasonable wage for working men, and where we live in the world today. Some of the consistencies I thought was the rapid social change that Frank mentioned occurring both then and now, battles between jurisdictions, states and Commonwealth government, and debates as to whether we should look to the market or to the government to regulate wages. On the inconsistent side of all points of difference between today's world and the one in which Justice Higgins was active in, I noted with the omission of women as earners in the 1891 debate, and also the change in Australia's status as a lead advocate for fairness on this issue in the international stage, and how this was recognised and how sorely this is missed, I think, today. A further marked difference, I think, is the way in which Higgins places people at the centre of this policy and the focus of policy decisions, as people being the most valuable asset, not as a means to an end, but as an end in themselves or ourselves. And although inconsistent with much of today's political narrative, this is a cornerstone of the work that we do at Jesuit Social Services across our programs. We put the people who are usually excluded from mainstream society at the centre of all our work. Our work is relational and people-centred, and we focus on the person. And although we work with many people who've experienced really a lot of trauma and have complex needs, we focus on the person and their strengths, not on the disability or the employment status on the homelessness or the mental health or the drug and alcohol problem. Our language exemplifies our approach here. We don't work with homeless people, we work with a person who's experiencing homelessness. We do not work with the mentally ill, we work with a person who has a diagnosed mental illness. It may sound trite or insignificant, but it isn't. It's an important philosophical and purposeful statement that promotes people, human dignity and humanity in all the work we do, and I'm sure a sentiment that Higgins would be supportive of. A clear example of this is one of the programs in which I coordinate at Jesuit Social Services is called the African Visitation and Mentoring Program, a program in which we recruit volunteers from the community to visit and mentor men and women of African backgrounds who are in the Victorian prison system. Most of the men and women in the program are of South Sudanese background, and they've survived war with all its atrocities and years in refugee camps. They've arrived here without language, without education, and with limited family and support. They've experienced racism, fear and ignorance, and they're traumatised and vulnerable. Their descent into prison is rooted in their trauma and disadvantage, which often leads them to substance abuse, self-medication and offending behaviour. Their mentors are community members who volunteer their time to visit them, and most have never been inside a prison. Some are of African background, some are not. It's a deliberate decision that we at Jesuit Social Services do not disclose the offence of these men and women to the community volunteers who will be visiting them. We want the humanity and the relationship to develop prior to the fear, assumptions and stereotypes. So again, I feel like Higgins, we're putting the people in this program at the centre of our work, even perhaps when the broader policy environment around us, and certainly the Victorian criminal justice system, does not. On the side of both consistencies, I think, and inconsistencies between Rerum Novarum and today, I note Pope Leo's reference to the enormous fortune of some individuals and the utter poverty of the masses. Unfortunately, a statement which does resonate strongly today. There is a strong and widening gap between rich and poor in Australia today. The people who we work with at Jesuit Social Services live in poverty, many in intergenerational poverty, and live on the margins of society with little or no prospect of even a basic wage or of work. They are working poor, but many also will never work. This is particularly true of our justice participants where I work. Finding work after a prison sentence is not impossible, but it's pretty tough. As many as 60% of people who leave prison are unemployed after a year after their release, which isn't surprising that given today we're looking at 11 people applying for the average job advertised, many of those without a criminal conviction. So what then for this group of people? How to live with meaning or purpose when you're denied this opportunity to work? Not only is this gap widening today, as discussed by Frank and his reference to Sally McManus, but it seems that to be in poverty in Australia today is also to be blamed personally for failing. The narrative that's developed in this space has focused on the failure or the poor choices of the individual, not on the total absence of Higgins' conditions for a civilized life, like provision of a basic wage. Jesuit Social Services spoke directly to this as part of our agenda for social change and our mission to build a just society when we conducted research into disadvantage in Victoria, the Dropping Off the Edge report. We examined 667 postcodes in Victoria and looked at 22 different indicators of disadvantage, including social wellbeing, health, community safety, access to housing, education and employment. And postcodes were then ranked according to that disadvantage. And what was found was that disadvantage is concentrated in a really small number of communities in Victoria. These communities experience a complex web of disadvantage. A significant number of postcodes have been depressed for long periods of time with persistent and entrenched nature of disadvantage. The nature of this disadvantage also now includes criminalisation. Just 6% of Victorian postcodes account for 50% or half the prison population. 40% of people in prison have a relative who has been imprisoned. 46% of people released from prison are released to homelessness. 42% of people in prison have a psychiatric risk rating. 2/3 have a drug and alcohol abuse problem. and just 6% of men and 14% of women have completed secondary education. 40% of the Victorian prison population are on remand. They are yet to be convicted or sentenced. So it seems that we have not only blamed communities for their own disadvantage and poverty, we have also criminalised them for it. And that culturally we are becoming a much more punitive society and a less just one. We now have a growing criminal justice system, spending for which exceeded $1 billion for the first time in 2015. And an increasingly punitive approach to people experiencing poverty and disadvantage. As Frank mentioned, we're looking at we now have Centrelink and a really punitive welfare system. Many people who have payments suspended for for failing to attend appointments, for not applying for enough jobs, 20 jobs per month. And as Frank mentioned, now the proposed drug testing of welfare recipients. It's further evidence of the punitive nature of what was once seen as a safety net. Young people are blamed for not working, despite the lack of entry-level jobs and the absence of manufacturing. So I feel like the narrative is now that being poor is an individual failure, not the reality that it is the outcome of structures that ensure poverty will ensue for many. So at the same time we've seen the rapid expansion of the criminal justice system, we've also seen a reduction in the amount of services available to the community. The result of this is that prisons are locking up some people who are violent offenders, but it's also locking up a number of people who are vulnerable. The criminalisation of poverty is an effective way of silencing voices and individualising and pathologising problems that are actually not at all individual, but social, both in design and execution. One area of inconsistency that I'll just close on my response tonight is gender that I noticed, and Frank spoke to this as well. Higgins was clearly a man of his era, and his idea of the minimum wage was focused on the idea of a working man, his wife, and 3 children. Today we know that women make up 46% of the Australian workforce, and as we know, they're still underpaid in this sector. Alongside this though, the 2016 census also showed that the average Australian woman spends between 5 and 14 hours a week of unpaid domestic housework. For the average Australian man, this is less than 5 hours. Regardless of employment status, the gender gaps in domestic duties linger over time and increase when children enter the picture. Women in Australia work part-time, often to do unpaid housework, and then lose out on economic resources. This means that women's total lifetime earnings are reduced. 1 in 3 Australian women retire with nothing in their superannuation. So Australian women are increasingly time poor, pressed, stressed and depressed. I actually think that a lot of men would like to spend more time at home with children and even doing some domestic duties, and that the workplace should provide more structures which allow men to do this more easily. Perhaps we all need to work shorter hours to do housework and child rearing and free up the time of both men and women to do this. Northern Europe, Finland, New Zealand and Canada and Switzerland and the Netherlands are starting to experiment with the notion of a universal basic income paid to all whether they work or not. Finland, for example, argues that it can provide a basic secure income to its entire population by cutting up the current benefits system. The Finns say that by guaranteeing basic survival, a government provides a service as necessary as, say, policing the streets. Then the government gets out entirely of attempting to regulate the labour market. Its goal of keeping people fed and clothed is already achieved. The Finnish government believes that the basic income scheme will encourage the currently unemployed to take part-time jobs, which they have otherwise avoided for fear of losing their benefits. They also argue that many people may agree to work for less than the current minimum wage and on more flexible terms if they're supplementing a guaranteed income, not scrambling to have to beg for food. And they say that there should be little incentive not to work at all, as the amount proposed in Finland hardly provides for a comfortable existence, but would allow for more part-time work, which would also provide for workplaces where parenting and the family, like Higgins, could be prioritised. So more flexibility in workplaces, a presumption of part-time for working parents, not just for women, but for men too. So finally, I think I'd really like to add my voice to both Justice Higgins and to Frank's and the call for a new province for law and order. One that is built on a social security system or a universal basic income that is both appropriate and respectful, that values people and has them as its central concern, that speaks to gender and to family. In my line of work in adult justice, the phrase law and order has very negative connotations, usually meaning harsher sentences that don't get to the root causes of crime. But in Justice Higgins and Frank's new province for law and order, I applaud the reclaiming of this language from the simplistic and unsuccessful populism of conservative politics to a call for a just society that is based, as Justice Higgins said, justice and humanity. Thanks very much.